about 5 minutes late. So I'll jump into chair because I know that Franz has got a few things to raise and we thought that might be an easier way to manage today. Um, so apologies wise, we have an apology from Deputy Mayor Ryan and apologies for lateness from Councillor Cowles, and I'm not sure where Councillor Hopkins went. He's coming, he's on his way. So he'll be here imminently. Do I have someone to move those apologies? Do we need to do that for workshop? No. All right, so essentially just to set the scene on this one, obviously we're now moving into the next phase of the Southern Waters discussion, which is trying to get all the agreements up and running so we can stand the organisation up. So what's happening from now is in the next couple of weeks, slowly we have each of the other 3 councils that we've asked to join. They will be passing resolutions on whether or not they accept our request to join Southern Waters, and they'll also have the same documents in front of them to work through. So I guess one thing is probably a rider on this. We had a few meetings in the interim. We've only been part of one of them because obviously we've not been long part of the conversation. We're an early part of the discussions around these. So they are where all the councils, the 4 of us, have landed per se. So I guess just framing that, we've got to keep in mind if we are making changes that we then need to pass it along for councils, and it could hold some processes up. So we've got to work out what our level of importance on those things are and what they aren't. So that's a discussion for today. And we're early enough in the piece, that's why we've done a workshop here today, so that we do have the option to move any suggestions we've got into the other councils before the meetings. I think the first one is, can you tell me that? Today. So today, the only issue would be if we wanted changes we made, that Gora's meeting today, but the rest of them, there is an ability to make changes if need be. So it would be one revisiting. So we've basically put this in as quickly as we can find space for it. And think it's, an important one. And so, don't know if there's anything else you wanted to start with.
To add a little bit more detail on that, so that our plan is that these will come to you formally on the 14th of April at an extraordinary council meeting, which is the next big step in terms of agreeing, subject obviously to those other councils agreeing to our entry, which hopefully they will do today and over the next few days. Then they will come to us. So this is the opportunity to really go through these and understand them. I should say, in terms of the assets work as well, which is important to redoing our water services delivery plan. That work is progressing. We've had the report on that. I think it was a couple of weeks later than we'd expected, the final report on the assets work. And I think if we get through these in time, we might consider going through that next week in terms of where we're at with the assets, because we've got another workshop in next week. Then the next key date will be the 14th, where we hopefully, subject to your agreement and satisfaction, agree to the various components that form us joining Southern Waters. And then the work will be to revise our water services delivery plan to submit that before the end of June this year. I'm hoping that we'll get that done earlier, but it depends on the progress with the remaining assets work. So we're actually on the ground now doing the physical investigation works, and hopefully you've seen the communications that the team have done on that, with holes being dug and pipes being tested.
And just, I guess, to expand, today being a public workshop as well, I know that Franz in particular has got a number of things to raise, which is going to be more around just making sure we have a good understanding of the documents in front of us. And I think that's a really helpful thing, especially in a workshop that's open to the public, so that it helps bring people along in that conversation. Councillor Holden.
Sorry, Alex might have sort of covered that as I was finding my paper. Just would you be able to, just in regards to the land holdings, just talk to that a little bit about why and how, or just with the transfer? And something I hadn't thought as much about.
So we've got to do a lot of work around the land holdings, but essentially all the assets connected with the delivery of water that's proposed would transfer to the CCO, which includes the land that they sit on. And I think the issue is then we've never looked at that land separately before. So some of that land has, dual purposes. And some assets sit on land that isn't fully needed for water. So we need to go through a process, as the other councils will, of assessing what land needs to transfer with that asset. But it'll still be essentially ours, but through the ownership of the CCO that we own that land asset and the water delivery assets that sit on that. Does that answer your question in that respect? Yeah.
Councillor Hopkins.
Yeah, Madam Chair, I have a number of questions, probably 5, 6 or even more. Also, there are typos on at least 4 pages, 4, 18, 72 and 98. Who do I see about those?
So I guess just to work out how we work through these, we're probably going to need to do it by attachment. So we do it by document rather than trying to throw the whole thing out. That way we can get a bit of a...
But this document here, there are various issues raised on certain pages that I would like to either question and we'll get clarification on. How are we going to do that?
So you've got 6 documents in total
Yes.
that's attached. So my suggestion is that with Paul and the team, we take it a document at a time. A little intro to the purpose of the document, maybe, and then we can answer questions and raise any issues or concerns that maybe need to be resolved with our partners.
Okay.
So if I get maybe Paul to introduce the document, and then if you've got questions for that document, I'll come back to you. And I'll just check with Dan, is yours in general or is it towards moving into the document detail?
No, it was just a general one. It was just off the back of Councillor Holding's query with regards to land transfer. Easements and that side of thing, is there going to be a process that we have to go through? Is that going to be something to ensure that easements follow, or is that going to be a sort of a legally onerous element of it as well?
I think that's 2 separate questions. I think Paul's looking to answer, but my understanding is that all the easements associated with water will transfer to the CCO as part of that process. But clearly, we need to make sure that we've got all the documentation together on those easements to transfer, which I'm confident we mostly have. But there will be a process of going through and checking that and making sure that it's all in place, ready for a legal transfer of those. I don't know whether, Paul, you want to add anything to that?
Yeah. Yeah, I mean, they'll just be transferred. It basically change our name to the Southern Water. There's also reasonably strong powers for Southern Water as a utility provider to pretty much go across almost any land as part of maintaining and protecting their infrastructure. So it's sort of a double approach, but certainly the easements, it shouldn't be a difficult process. It will just be a matter of identifying them. And then just very much like the novation process that will go through a lot of the contracts and other illegal agreements, and it just their name just gets substituted for ours, but they pick up all the rights and responsibilities of any of those agreements.
Now, Councillor Hopkins, is there anything in general, rather than into the detail of the programs, that you wanted to raise any questions before we start?
Yes, there is one general matter that I think all the documents are silent on, and that I think we might want to consider incorporating in some way, and that is, I can see no reference anywhere to what might happen if everything went totally pear-shaped. And supposing after some period of time, Southern Waters was deemed to be a catastrophic failure, and the 3 councils decided to essentially departner and put the CCO out of business. I know that in law, I think the assets remain ours, but is there a need, do you think, in the very unlikely event that that would happen, is there a need to have some form of procedure or process or addressing of that matter?
So I think, as you noted, Councillor Hopkins, that's a legislative issue, not a sort of foundational issue of these documents. So it would basically revert to the water services legislation, what would happen in that circumstance. But the whole legislation is designed to make sure that doesn't happen, really through the regulatory regime that they are need to operate under. So effectively, if the company is not meeting its regulatory requirements, so there would be quite a bit of early warning before the company began to fail. Essentially, the administration of that company could potentially be taken over by the regulator to make sure it did operate. And essentially, what that would mean is the board's not discharging their responsibility, so the directors would be in the gun. If the directors are not being, I mean, that's where the responsibility will fall to make sure that these entities are generating sufficient revenues to meet their obligations. So it would have to be a catastrophic failure, and that would be dealt through legislation, because really once council will still have responsibilities in this area, so when the council will not be sort of completely off the hook. So again, it will be the responsibility of the stakeholder group and the shareholding councils to monitor the performance of the company, to be aware of what's going on in the regulatory space, and really they should be intervening before the regulator does, but there's lots of points to make sure that doesn't happen. So again, I don't think it needs to be addressed in these documents. It would fall back into essentially a higher level.
And I believe it does outline in the documents that the councils remain joint and severally liable. So we basically, if it all did fall over, there are still councils that sit and they do pick up the pieces essentially. But I think there'll be another process, as Paul mentioned, that would take over before that happened. John.
Just a couple of things, and I'll probably get back to it later. As far as rural water schemes go and access, we used to have a warrant that allowed us access onto those who look after assets. Now, is that still, I haven't seen anywhere in here at all, is that still on the page? And the second thing was, I suppose we're going to get into that in the document, so we can't get in there, but that's the first question.
Yes, but like Jim's question, that is actually a statutory authority. It doesn't need to be addressed through these documents. So they're given that power through some of the waters legislation.
All right, so what we'll do, if we go through document by document, and Paul, if you wouldn't mind just introducing the intent of each sort of document, and then we can take any questions pertaining to that document.
So sorry, I'm a bit late. I was operating on a different timetable and thought that was starting at 10:15. So I thought I was 10 minutes early, not 5 minutes late. So apologies for that. And sorry, missing the introduction. Yes, we're just working through these documents. What it will lead to, as Alex noted, is a report in April. If you want to get a preview of what the report will look like, I suggest you log into have a look at the Gore District Council meeting agenda for today. So it's got the report where they will be considering their version of all of these items. I know counted up and almost ran out of fingers. So there are 13 recommendations in their report in relation to all of these water matters. So you've seen some of those here, but it also includes things like acknowledging, giving permission for, or giving approval to set up Southern Water as a CCO, get the company registered, accept the appointment of the establishment chair. So just a whole lot of items that will be sort of agreed to on the day. But the critical ones are the documents you see in front of you. In the covering note, I extracted some of the materials from the generic report that Southern Water provided. So just trying to be consistent in the wording, and that's why I put it in italics, so you understand it's sort of their words, not mine. But didn't need to see any point re-editing those. Just when I think it was quite clear about what the intent was. It's probably, I think the key document will be the transfer agreement. And all that will be agreed to is that that will be negotiated and it will be in a form similar to the one that is that's been distributed. So that's not the final document. That's the big piece to negotiate because there will be the devil will be in the detail and we'll need to work through that and agree that. So that will come back later. So it's really really probably the first four, and then it gets down to two of those are pretty straightforward. So it's really the constitution and the shareholder agreement that are the main focus, I think, of the workshop today. So the first two, said I think they are relatively straightforward because they have been previously agreed to by council back in February, and these are just really re-entering those agreements. And so with some minor amendments, but those minor amendments are really due to dates and format to allow us to re-enter rather than join as an original partner. So it's probably, if we don't mind, if we deal with those two first, and then we'll get into the more significant ones.
Paul, just to clarify on that, so obviously, the last council saw the commitment agreement. I note that, the commitment agreement isn't attached to here, so I'm wondering whether we need to circulate that around so that, those members, particularly new members, can see what that commitment agreement involved, because the document circulated is the deed of accession, an amendment which is for the other councils to agree to, and Waitaki entering, which we also need to sign up to as well.
Yeah, we can certainly do that.
Sorry, Paul, just on page 4, as far as the draft constitution, I presume those numbers the directors will change. That'll be under if they take us to come on board, it'll be a minimum of 4 and a maximum of 8. Is that as it reads at the minute? Otherwise, that's a dangerous scenario.
So no, I'm not quite understanding why board generally even numbers are a dangerous scenario, but that's why they've gone 3 to 7.
3 means that you can outvote 1, is where I'm sitting. So what I'm saying is this is about a representation of each district, to be fair. So at some stage there should be 1 person representing each district, so nothing gets left behind. Jim, it says directors maximum of 7, minimum of 3.
Can I suggest we go through a document at a time, because we're leaping ahead. So and confusing the constitution with the shareholders agreement and the different representation. So that the board of directors is different from the stakeholder representation group.
Yes. So we'll come back to that. So if we start with the cost sharing, and if there's anything in the cost sharing anyone wants to raise, it essentially says that when it comes to the stand-up costs, all the councils will work together.
So are we looking at attachment 1, 2, and 4?
Page 6, attachment 3. Sorry, it's a wee bit confusing through the attachments. Mr. Hope.
Just as a note on the cost sharing, that was primarily in the initial stage where we did do the cost sharing. We actually, Waitaki administered that. That's where we received in the funding received from the Crown to help with the process. The net cost to each council ended up being about $25,000. So that was quite good. The costs from now on incurred by Southern Water will be captured by Southern Water, capitalised and transferred over as an establishment cost for the organisation. So really the only costs that the councils will be facing is the individual costs. So really this is very procedural. The cost sharing agreement's pretty much met the end of its natural life, but it just needs to be in place for any minor amounts that may occur into the future.
Right, is there a level of comfort there, councillors? Great, we'll move on then to what is named attachment 2, the deed of accession and amendment. Page 9. Just get everyone onto that document.
Just a very more for reassurance in anything. Under terms 2C, the date currently shown as a void will be, I presume, the date that whoever signs on our behalf actually does so. Is that correct?
That's correct. These are just generic documents and they'll be edited for each of the councils as necessary.
So on the deed of accession and amendment, is there any questions on that one? Again, it's probably not the pertinent document. No. So what we'll do is we'll move now on to, I believe it's the Constitution next, is it? Page 15, Constitution, which is probably where the rubber hits the road a little bit more. Do you want to just introduce this document?
Yeah, as sort of noted, these are very closely based on templates that were prepared by the Department of Internal Affairs, so they fully comply with the requirements of the various parts of the water legislation. They've been had a little bit of tailoring to match the requirements of Southern Water and the proposed structure. So I think it's rather than me go into a lengthy explanation, because a lot of the pieces are pretty standard and are needed to be there to form the company, but a lot of the provisions will probably never be used in real life. So once it's established, it'll move on pretty smoothly. But yeah, very happy to answer questions. I think it'll be more effective than sort of talking about each section.
All right, so into the Constitution, is there anyone that has any particular questions on this document? Councillor Hopkins.
Yeah, I have a number. Starting with page 20, I'm just wondering if we are comfortable with under 4 shares, 4.2, subject to this Constitution, the Shareholders Agreement and the LGWS Act, the board may issue shares at any time to any person listed in clause 7.4b or any other person permitted to hold shares in accordance with the Act and in such numbers as it sees fit. Now, are we happy with that? I mean, basically that means the board of the company, as I read that, it can say, oh, well, we'll give Jim 1,000 shares because we like the look of his haircut. I'm being very frivolous, but it does seem to be quite an extraordinarily broad provision.
So perhaps the lawyer in the room might chip in at some stage, but no, I mean, the board needs to be able to issue shares. There is then a whole lot of other protections and procedures to actually put how those shares are issued and who they're issued to in place. This really just gives the board the power to actually undertake a transaction that has been approved through other processes. So it has to sit with one group, and that one group is the board.
Can I just add to that? You need to read that clause in conjunction with the other clauses and the legislation. So there is a restriction on who can own water CCOs in law. It's only local authorities that can do that. So yeah, that's the provisions really to prevent privatisation of these entities that the government's included in there. But this provision, if you read it in conjunction with 7.4, is really to accommodate any changes that might happen in local government, whereby we need to factor in, simplifying local government might mean that, some of the councils that are part of this don't exist in that form anymore. And so there needs to be a provision in there for those shares to be issued. So it's not, whilst when you read it in isolation, it looks like it's giving a lot of power to the board. When you read it in conjunction with the other clauses and with the legislation, it's very restrictive in terms of what they can do.
And I'll just
a question supplementary then, for the point of clarification, perhaps for everyone, would it make sense to add to that as it thinks fit and in terms of the legislation or something like that?
Well, I think the legislation comes into effect anyway, but I will pass to Amy, who's got her hand up online. Thank you, Amy. You're not making noise yet.
No, thanks. Sorry, rookie error. I can't help myself. Sorry, the lawyer in me. Jim, I think the point you're missing is the last line of 4.2, which makes it very clear, provided that no shares may be issued unless the issue is first approved by special resolution, which means that 75% of councils have to agree first. So even though it says they can, that proviso at the bottom overrules it. Which makes it absolutely clear that it's actually up to the shareholders. So when I read this, my thinking was, if another council wanted to join, then obviously you have to issue more shares to enable that to happen. So the board has the power to do it, but they can only do it if the shareholders by majority, 75% majority, control it. So it really does put all the power in the council's hands for that one.
Thank you.
Councillor Slack.
Yeah, basically echo what's already been said, and correct me if I'm wrong, Paul, but I believe this falls under the reserve matters for the shareholders agreement. So you really need to read this, and then together with the whole shareholder agreement, where it is a reserve matter, as for only for the shareholders to decide who can have more shares or can have shares. So it is a tick-tock play, if you like, between documents where you have to keep referencing to other ones. It's something that I noted in the beginning, and then actually once you get through the shareholders agreement, you come to the point where you're going, oh, the directors by themselves or the board can't do that. So yeah, it's understandable it is highlighted, but there is a protection in place for that.
Paul, did you want to add?
So it also, particularly in relation to the B shares, so that's probably the first time that there'll be more shares issued. So in the transfer agreement, it talks about essentially there'll be an initial assessment based on some initial values, and then within 2 years, those values will be adjusted for any other changes that have been identified in the 2-year period. So there'll be a process where basically the shares are adjusted back to the sort of final values, net values that each of the councils have put into the entity. But again, those B shares aren't voting shares. They're there just to recognise the value of the input. The key shares are the A shares that have the voting rights.
I'm just conscious some of us are closer to this than others. So I don't know whether people have picked up on there's 2 share categories. So the A shares are the voting shares, which is basically one council, one vote. And the B shares are a reflection of the asset value transfer. Recognising that each council have different values of assets. So it's just trying to accommodate that. But they're non-voting shares, yeah. And so that's why you've got A shares and B shares within there to reflect different factors. One, the voting, and the second one, the value of assets transferred.
So, Councillor Hopkins, that first issue raised, are you comfortable with the response on?
Yes, I am.
Perfect. If you move on to
Okay. So on page 24, there's a reference to committees, 11.3, appointment and removal by stakeholders. Where there is a vacancy on the board, the Appointments and Accountability Committee established by the board, or where the board so determines the full board, may by majority vote appoint a person to fill that vacancy. So my question is, have the committees to be established already been appointed? How is it that this constitution identifies a committee to be established by the board when, as far as I'm aware, well, we don't have a board at the moment. So my question is, have committees been agreed, and what committees have been agreed and or established already?
So yeah, that is a committee of the board of the entity. And this is really to allow the board to appoint an interim director until the full director appointment process can be undertaken by the shareholders. So if initially, say, there were only 3 directors established, which I think is possible, and as the entity gets going and one of those resigns, you need to have a 3rd director appointed so the board can appoint that interim director until the full board appointment process can happen. So this is a committee of the board, not a council committee or anything that the stakeholder group would be involved with. It's an administrative process again to allow the company to maintain its sort of legal status and the other requirements of the establishment documents. And that's why it's a may, not a shall. So it's really just so that the board can make additions so the board stays functioning.
Thank you. My next questions relate to the shareholders' agreement. So as far as the constitution is concerned, I've asked so.
Right, was there any other questions on the, thank you, Councillor Slack, or I'll go to Councillor McCone first, and then Councillor Slack.
I'm assuming amongst all this, the overarching is the New Zealand Audit Department that actually keeps an eye on all things possible under the way the system's run. Is that how are they going to be sort of like the watchdog over the top?
So, sorry, not to be too pedantic, but yeah, it's the Office of the Auditor General has responsibility for these entities. They will then appoint an audit provider. So it may not be, and probably it's unlikely to be Audit New Zealand. They'll probably look at engaging one of the big four auditing firms to conduct the audit of all of these organisations. But then they will have the scope that they normally do for an audit, but it's not, it will not only be them. I think they'll have greater accountability back to the Commerce Commission in terms of how they run and operate and all of their disclosures back to them, and then of course to Mata Arawai in terms of their operations, water standards and compliance with legislation, and then of course regional councils or their replacement. So yeah, these will be heavily regulated bodies, and all of those regulators will impose requirements on the board and the directors.
Thank you, Paul. Sounds like a lot more expense.
Now, before I go to you, Franz, I'll go to Amy online and then I'll pass to Franz.
Thank you, Madam Mayor. Look, I've just got these documents this morning, so forgive me, I'm just absorbing them as we're going through this process. But there is one point that I think would use some clarification, which is around, it follows on a little bit from Jim's point around the appointment of directors. 11.2 and 11.3 do seem on the face of them to be slightly contradictory. So this is around who appoints the directors, and boards can work in different ways. The shareholders can appoint them, or the board can appoint their own directors. 11.2 makes it clear that certainly the initial directors are put in place by the shareholders reference group. That's fine. But then it goes on to say, and directors may be removed and replaced in the same way, i.e. by the shareholders reference group. But then you've got 11.3 that says that the board itself through that committee is the one that removes and replaces directors. So it could be that that's to fill temporary vacancies, and then those are confirmed by shareholders at the general meeting. Or it could be that the shareholders are only responsible for appointing the initial directors. But I don't think on the face of it, it's clear how that's intended to work. And I would think that it's important for the councils to be very clear whether the board is a matter that is for the shareholders to appoint and replace as required, or whether once it's set up, the board maintains that for itself. So someone can correct me if I've missed something, but looking at the two of those, they do seem to be contradictory.
So maybe we need to go back and just confirm the temporary nature of that to fill a gap.
Mm.
So thank you, Amy. Councillor Slack.
Thank you, Madam Chair. Beforehand, I just want to say, obviously, we were part of, you and I were part as the steering group of that first meeting that was held. And out of there came a few discussions, and I'm just going to put a few questions here also to inform all colleagues around the table. I think this is a good forum for it. And on page 25, we're still in 11.5b. No director may be appointed for a total term of more than 9 years. But there was discussion around the table in that meeting that we had whether a director that was too valuable to lose out of the board, whether there should be an opportunity to still be able to reappoint that director. And I sort of forgot, and maybe you can help me with that, where we landed on that.
Well, I think that the question was framed a wee bit differently, that some people thought that 9 years was too long in that conversation. So the question was, does that need to come to a shorter period? I think the discussion revolved around that. And I know my thoughts were that 9 years is a good length to keep out there if you have got a really good director to keep them on if they're doing the job. But yeah, there certainly was discussion because some thought that was too long. Alex?
So, and part of that discussion was recognizing that, directors hold a different status than, say, employees. So, whilst there's an allowance for a term of up to 9 years, their term comes to an end every 3 years, and you don't need to reappoint them then. There's not an obligation to do that. You can change that out, but at the same time, you want some degree of continuity. We have seen it before, with directors, particularly if there is an issue of continuity. So say you've had a number of directors leave and the 1 or 2 remaining directors have come towards the end of their 9 years, you can make an exception to that. I'm not quite clear how that would happen in terms of this constitution, but I think that the shareholders would need to agree that some sort of special resolution between them to extend if there was particular circumstances that where it was in the interest of the company and continuity to extend that term beyond 9 years.
Again, on the Constitution, we're at page 28, 15.1c, and read it also with A and B in mind. And Miss Amy Adams, don't get me wrong here. It simply states 1 or more attorneys appointed by the company, which can actually sign a deed. I question the fact that only one attorney, one rogue attorney, for whatever reason, could actually enter in a deed on behalf of the Southern Waters company. Why only one?
That's a reasonable question. I'm not sure if anyone's got a take on.
I can help you with that if you like. It's not attorney as in lawyer, it's attorney as in a power of attorney holder. So it would only be if the company had granted a power of attorney to a person to act on its behalf. So read it in that sense of attorney, not attorney as in any old lawyer.
Does it help, Councillor Slack?
I'm not going to argue with a lawyer, I'll be in trouble. But then it raises the question, who is authorised to actually grant the power of attorney? Is that 1 or 2 directors?
It would
Well,
be 2 directors, yeah.
I was going to say 2 or more directors at the start. I'm guessing that C has to have the support of 2 or more directors to be appointed. Would that be reasonable? I'll pass back to you, Councillor Slack.
Just checking because just to make sure that we're still.
Oh, your mic's off again now.
I'm just checking just to make sure we're still on the Constitution. I haven't actually put them in this order here.
Finishes on page 33.
Yep, I'm on 2.1, which is on page 29. Each shareholder and every director of the company must be sent written notice. And the question then I've got is that should directors actually be included, considering these are the rules for shareholders meetings? Should the directors be sent this written notice or being part of the shareholders meetings?
Can you repeat what number you're talking about there? Sorry, Councillor Slack.
2.1. So my question is, should the directors actually be invited to the shareholders meetings?
I guess, is it an invite or is it a being aware of when the meeting is?
Why not?
I would have thought the directors are probably the ones that should have an invite to every meeting, and the shareholders probably don't need to be at every meeting, but it's an awareness of, but that's just probably where I sit on that one.
Yeah, I sort of read that that is the intent in there. It was just the way that it was worded. It actually read like the directors were invited to the shareholders meetings, which I don't think would be correct.
Well, they may be a part of it. They certainly want to be aware, and they may need to feed into bits of the meeting, I would have thought, but Mr. Hope.
Again, I think, yeah, there is that very critical relationship between the shareholders and the directors. So if it's a formal shareholder meeting, I think, the directors should be aware of it and invited to it. Yeah, as they said, they don't need to be present for every item. So if there was a discussion about director appointments, they'd probably be excused from that discussion. But I think it is important that they're both aware, and particularly, you don't want a director being not invited, so they're not aware of something that's going on that may be fundamental to the company that they're responsible for delivering on behalf of the shareholder. So, it's just, again, formal process to make sure that there's a robust process in place to make sure that both sides continue to talk to each other and understand the relationship and the obligation between the two.
Yeah, okay. Thank you. Mel, I just had to pop out for a minute, so I'm just gonna basically pop here. Any other questions, Councillor McCann?
I understand the constitution is going to be written, but this is just off the. I don't have any problem with shareholders or directors or even operations people attending those meetings, because communication is the key to the whole thing working properly. And I think while that's got to be written there, you could actually expand on that if you had to.
Yeah, I think you're exactly right, Councillor McCone. This is just the default and bare minimum. I think what will actually take place and how it evolve will be significantly more detailed. This and a clearer understanding. I mean, this is there are some joint CCOs, but they're not common. So I think they'll establish their own practice about how best to engage through the stakeholder group, with the shareholders and with the communities in general. So, but yeah, this is the absolute bare minimum that will be undertaken.
Councillor Thelney.
I just want to go back to 11.2 and 11.3 on page 24 and test my understanding. So 11.3 allows the director's appointment by the board. 11.2 by the stakeholders. The way I read it, the stakeholders still have the ultimate say in 11.2. Is there a hierarchy there?
Yeah, I think that's the point Amy made, that needs to be clarified, that there is a hierarchy, that any appointments under 3 are temporary and would need to be away for need to check whether it's the shareholders or the stakeholders. I think it's the shareholders. Actually either endorse those appointment or start a separate appointment process. So I think that is a good clarification that we'll seek.
Anything else there, Councillor Thelney?
No, that's all good.
Go on to Councillor Lewis.
Just diving back to page 22, 7.5. It refers to registration of any transfer of a share to any person. And I'm just wondering if that would be better suited to any entity, given that it's not actually a natural person that's going to be holding those shares. If that would just clarify and alleviate any potential concern that individuals might be transferred shares.
I think this goes back to the earlier point that they can't. I mean, this is using a template that was based off something. It's like, well, should it be struck out or leave it in the template? But essentially, it would be ultra vires to issue shares to a person. So yeah, I think it's a good one. Well, why does it need to be there? But if it can never be used, we'll raise it with them, and I'm sure the lawyers will come back with a compelling response about why it should be there, just in case. Who knows what might happen in 100 years' time?
All right, so we can question that, but we've got probably two main points at this stage on this document, if there's nothing else that I've missed in there. So if everyone is relatively comfortable in that space, we've got the feedback we need there, Mr. Hope, for that one.
Yes, thank you. Yeah, and I think both these would fall under they're not, these are minor, would be minor amendments and clarifications. So I think it should be able to go through and sort of the last resolution that Gore will be hopefully passing today is, authority for the chief executive and the various others to make minor amendments to these documents as required. So I think, again, in both these cases, it's just minor clarification and not, well, perhaps maybe a medium clarification in terms of that priority issue.
Perfect. Mr. Councillor McCone.
Just as clarify, this will become a live document, but because we're at a beginning and an end, is there a timeline that this can be actually reviewed? Is there a review on it? Because it's a starting business and we never get it right the first time. But is there a gap in the system that this can be reviewed, say, in 12 months' time, 24 months' time, to make sure we do get it right?
Yeah, I mean, these are, there's always a way to review these documents. If any issue comes up that is basically not, isn't functioning correctly or as intended, then that would default back to, I think it's be either an AGM issue to amend these. And I think it would be a reserved matter, so it would need probably pretty much everyone to agree to the change. So I think, yeah, there is certainly it's not like a policy where it needs to be reviewed every 2 years. It's really only when issues arise where it's not functioning as intended, or there's been maybe a major change in legislation. So there might be something in the waters legislation that changes later on that needs to be reflected back into these documents, and then there would be a process to do that. But it's certainly not like a policy where it's like, every 2 years you need to do a formal review of these foundation documents.
I suppose what I'm asking is just teething problems, Paul, more than anything. And once we get that out of the way, it should be straightforward. I totally get what you're saying.
Yeah, I guess with the setup, we can certainly, if we see an issue, the councils can work together to revisit and to fix that. But I don't think there's an actual kind of plan to do that within sort of 12 months or anything like that. All right, so we'll move on to the shareholders agreement. Does anyone have a page number? Because we've got no bookmarks, or I don't have any bookmarks in this. Went back to the start.
Include the schedule to go through
34 councillors.
67. 67 is attachment 5A.
Thank you.
Transfer agreement.
All right, I'll pass back to you, Mr. Hope.
So yeah, there's probably a few more items to discuss and get clarification in this document because it is more tailored to Southern Waters. I think it is probably one is the differentiation they're making between stakeholders and shareholders. So I think probably if you want clarification around that, that would be useful. And then, yeah, I think that's probably the key feature of how that stakeholder group will work. I think you have to realise for this to work in a practical measure, that group will need to have quite strong delegations to agree matters, and then it will be up to each council how it actually has its relationship and how it gives direction to its one or two members of the stakeholder group. It's not captured in these because that is up to each council to work out. But once they will have to be able to make decisions, particularly in terms of things like the letter of expectation. Can't just it won't be practical to sort of get into. It has to go back to each council and into the group, and back to council and into the group. So the councils will need to work out how they want that to work, but for it to be on a practical basis, the stakeholder group will need to have decision-making power. So it's probably good to discuss that, get any clarification and really any other issues. Perhaps Mr. Palmer wants to add something as well.
Yeah, I was just adding, some clarification. So that the board runs the company, and the board is appointed by the shareholders, and so the company is ultimately accountable to the shareholders, but through this stakeholder group, which is a mechanism for bringing not just the shareholders but some other interests together to provide some direction to the company. So, for example, rural water representation on there as a key interest in there. Ultimately, still the power remains with the shareholders, but it's a practical thing, recognizing that, getting four councils together and to agree everything, every line detail of a statement of expectation is difficult, and also recognizing that in the long term, that group of councils may grow as we get consolidation there. So it's setting up a mechanism that's trying to be future-proof so that the company can have clear direction, and we're not just wrapped up in bureaucracy of, having to get things through councils and, constant amendments and such like, so that the company can have that clear direction.
Councillor Slack, I wonder if we want to kick off with you. I just feel like you've probably been through this document and it might be a good scene setter, and then we can come back to questions that aren't covered after that, if everyone's comfortable with that. And I'll come to you next, Councillor Hopkins.
Yeah, I'm fine with that. I'm moving to page 45 and the definition statement of expectation. I think that statement of expectation, and it says has the meaning giving it to in the LGWS Act. I think it should what should be added there in Schedule 1, other matters to be included in the statement of expectations, because under Schedule 1 there is some definitive expectations explained there, and they should be included in it.
So you want that within this, I guess we're in the summary kind of what the terms mean. You want that clarified?
Yeah, basically add after act, add there in Schedule 1 other matters to be included in the statement of expectation, because there's some key expectations in that Schedule 1.
That's looking around, but I think that's probably a reasonable. So it's basically saying that the statement of expectation has meaning given into it by the Local Government Water Services Act, but also the statement of intent. So it's basically saying that there's two kind of meanings provided to the statement of expectations. So yeah, just recognising that's, I think that's probably a reasonable and probably not a material difference. Would that be fair, Mr. Hope?
No.
No?
I don't see it as material, just to add clarity in the definition when the materials essentially included in the document.
Thank you.
If I can be cheeky, once you find Schedule 1, I think sure that you'll find what I mean.
Right. Was there anything else there, Councillor Slack? Or I can go on to other councillors' questions in the interim. Councillor Hopkins.
Yeah, a couple of questions here. Paul, I'm just wondering, it seems to me if you look at 6.2, that the only people who can appoint people to and thereby constitute the stakeholders representative group are shareholders, because 6.2 says each shareholder will appoint 2 members to the stakeholders representative group. So it does seem to me that stakeholders representative group simply happens to be a title that the document has settled on to describe how the shareholders will represent themselves. My question really is, has that representative stakeholders / shareholders representative group been formed already? And if not, when will it be formed? And I presume we won't be able to join it until we've signed the documents. Is that correct?
No, I don't. I agree. I don't think it will legally be able to be formed until the company is formed. However, there is an equivalent of that group at the moment. So sorry, there's so many 3-word acronym, abbreviations. It's the steering group has, again, the 2 members from each council acting in the place of the stakeholder group. But the process to appointing stakeholders into that, one will be essentially undertaken by iwi, and the other, it's by a process to identify the rural water representative. So
this steering group is perhaps slightly more informal. Have we asked if we can be added to it on an informal basis, or are we still out of the loop?
We're part of it on an informal basis, so we are very much at the table at the moment. And I guess probably the paper that comes to council needs to clarify that the steering group, well, I guess the recommendation will be turns into the members that are on the stakeholders group. But that's still, I guess, a conversation for us to have as well. So it will be a decision to be made by council.
I have some other questions, Madam Chair. May I put them now? Well, the next one is on the next page. I don't know whether John's picked this up or not, but I have concern about 610. Everyone, councils, mana whenua and others, will be appointing people to the stakeholder representative group. Well, all of those groups are given the entitlement of 2 people on that group. Rural water representatives, however, this is for 4 councils, will only have 1 representative. And I question whether that's enough, given the number of rural water schemes and the differences between them in different areas. I personally would like to see at least 2 rural water reps, not 1. And I'm wondering whether other councillors would share that view.
Just to respond to that, I guess we've got to remember that we also have our council representatives coming. So we've got our individualised council kind of thoughts to the table, but also 1 person looking over the rural water. I do think that we probably we want to be mindful of a few things. One is the number of people at the table, but also I think we need to make sure the rural viewpoint is put. And that's something that we need to make sure we're comfortable with what's coming to councillors on that. But we're still covered as council, and then we've got the viewpoint on top of that. I'm personally comfortable, but it is certainly something we can discuss. But this has obviously been something that they've landed on before we became members. And I thought that having that rural water seat was a really good addition to the stakeholders group. I don't know that an extra voice in that is going to do anything rather than muddy the waters, if you will. But that's just my view. That's a really bad pun, sorry. Alex?
I think I'd add to that. So rural waters is only an issue for 2 of the councils in here at the moment. So in most councils where most water entities where they're taking this forward, they don't have other interests represented on here. So this is a special provision recognising that rural water is important to Waitaki and Clutha, but it isn't an issue for the other councils. So it's not about being a direct representative of all those schemes, but it's about providing that rural perspective to that, to some particular issues that persist, within Waitaki and Clutha. And I think if I was in the other councils, I wouldn't be very favourable towards another rural representative, because it starts to imbalance the stakeholder representation group really for an issue that is just pertinent to 2 of the councils currently.
Yeah, I'd make the point that presumably the rural water reps would be principally required to comment on rural water matters. And my proposal to have possibly 2 rather than 1 means the total number of people on the stakeholder representative group would be 12, not 11. So it's not a massive increase.
But
and
I
it may be
think
that
it does change the balance of the group. And so what we're saying is there's 2 councils at play here that have that interest. And when you could sort of argue that then the vote's going to be skewed in those councils' favour. So I think that we would probably struggle. I think we've been lucky to have a recognition this is different, but we're probably pushing the barrow out too far would be my guess. I'm going to go to Councillor McCone and then Councillor Thowning on this, because I think they're probably on the same topic. Would that be fair?
So no, look, I support Jim on that scenario, but whether it's got to be a seat around the table or there's a subcommittee that reports to the one representative, I think there's a way around it. But somewhere it's got to be resolved, and I'm very pleased that it is being picked up in here because it's a huge part of the system, and you're going to get a heap of pushback if you start pinging these guys for bills that they've already paid and they're not expecting to support an urban situation. If I may just go back to page, no, I'll come back to that one.
Just come
Yeah,
back to that
sorry.
one.
Yeah, I'll
So
come back.
I'll move to councillor Downing first on this topic, and then we'll go back to councillor Hopkins and then on to you.
On the rural water representative, says engaging with selected stakeholders, but there's nothing in there about how they're selected or who they are. Could we get something put in there just to clarify who's being engaged with?
My thought would be that we don't want that necessarily in the stakeholders thing. I think that's a conversation for the stakeholders group to have about how they select those people. So you don't want to be too directive in this document because it's not that group that they're selecting right now. And I think there's got to be the work that falls out of that because the conversations haven't been had and they're not going to probably hold up these documents.
So it's, I think that refers to selecting the stakeholders who select the person that will sit in the seat. So it would be fundamental to the shareholders agreement, I think. But it would be, well, it's just my view, it would be good if it was clear who the selected stakeholders are, even if it just name the councils that are rural, or I don't know the answer.
Well, I think the conversations that have been had at the steering group meetings have been very much around that. This isn't about, hey, we're going to name a Waitaki councillor or representative or a Clutha representative. It's someone that can look across the whole. So it may even be someone that's got expertise that sits out of those regions. So there's not a bias in that. But there's discussions still to be had as to what that looks like. But it's a discussion for the stakeholders, I think, to bring that, to select that person that they're comfortable with. I know that's not probably quite as clear as you'd like to see, but I wonder how much clarity we can really give to that until there's a discussion and a process.
Yeah, I understand where that's coming from, but we've also got to remember each rural water scheme is geographically challenged, so you can't, one spot doesn't fit all. So we've got to be very careful how we organise that or get a group together that reports to it. I'm not sure how it's done, but I think there's an opportunity there to get it right from the start, because there's a lot of intellectual knowledge out there that needs to be used.
I'm supportive of what the intention is in terms of representation, but can there be a mechanism in the constitution to include it? It'll be consistent with the act to make sure that the skills, qualifications and interests, and then you just disclose any interest through the procedure. So it's just something to consider. If it's not appropriate to put in here, then there should be another avenue to include it just to protect our interests.
Up to us. I mean, when we are considering the appointment of the two people who are going to be our reps on the group, won't we, in the public interest and in our own interests, appoint people whom we believe will best represent the totality of Waitaki's concerns?
Yes. I guess.
So I'm wondering whether there actually needs to be anything incorporated beyond that.
I guess just taking Councillor Taiti Finini's comment, I think we need to find a place for where that is clarified, but I don't know that it's a stakeholders document myself, because we're setting it up, and I think then we need to have a process around how those people are selected. So it's looking for some clarity around that, but also not wanting to hold up the process now to getting the entities set up, really. Would that be fair?
Yeah, I think this is an instance where, Councillor McCone's comment earlier on, this may be something that, you need a few iterations of the process, how to do it before you want to embed it in one of these documents. I think, so this is giving enough flexibility to allow that to occur. I think, yeah, identifying the stakeholders, but it does say promptly. So, this will be a task, a very early task for the stakeholder group to establish what they think is an appropriate mechanism to do that. I think once they may say, oh yeah, well, we've now got a good, strong, robust process and we want to actually embed it back into the document, and it could be done that way. I think, trying to be too prescriptive now, I think it's like, it should be a member of the water committee, or it should be a councillor with a rural background. I mean, I think you're better to work through it, see what comes out of the woodwork, work through it a few times, see that works, and then possibly embed it later on. But I think this is, I think there would have been extensive discussion of this, and I think, Clutha, I think you could almost guarantee have been very strongly advocating for this position and coming up with a robust solution. So I think perhaps rely on the work they've done to come up with something that's both practical and robust in this initiation stage.
So I'm going to go to Councillor Lewis and then up to Brent online, and then to Councillor Thowling. I know he's out.
Thanks, Madam Mayor. Considering that rural water is important to Waitaki and Clutha, presumably for Central Otago and Gore, would commercial water be equally as important? And is that one way of balancing that requirement without it getting bigger than Ben Hur?
Interesting. This was an issue with Timaru. Commercial users are not that different from domestic users. They are essentially getting the same product. They're just getting a greater volume of it and may have a different charging mechanism. Why I think both councils were very keen to recognise rural. It's because they are mixed use supplies, so they create a number of different decision points, whereas the commercial, essentially it will be almost a direct negotiation with large commercial users about what's the service they need, what's the volume they need, they will have a comment on the charging mechanism, but maybe it will be up to the company to determine what's fair and appropriate and meets their regulatory requirements. But I think it's the reason for this is that they get a very different service than everybody else, and that needs to be recognised in the way the company operates. So I think that's why the distinction was made. Whereas it's just, we need a bigger pipe, and it needs to be of the standard, and that's what commercial users are after. If they then try and I'm not going any further than that.
Just to that though, that has a huge bearing and implication on the infrastructure that's put in place, and also the future capacity for that as well. That is something that I think is, we do need to take into consideration with regards to that.
I think that's part of the general setup of the whole shareholders group, is how we allow our communities to grow, and through our spatial plans and things like that as well. I think it's where you start to feed that into this. So I don't think it's lost in the conversation, but I think that there's probably not quite the specialist attention needed in that direction. I'll take you quick. I've just got a bit of a line up actually, so I might just pause that for a second and go to Councillor Cowles online, and then Councillor Slack, then Councillor Hopkins.
Thanks, team. Look, I'm sitting relatively comfortable. There's been some good questions brought up, but I guess I keep going back to the fact that we're all, I guess the intent of this is to come together, and there's still a lot to work out between us. There's going to be some changes. I don't think we're going to get it right the first time, but that's going to be for all of us. It's not going to be just for us, I think. And I think the intent's there. We are treating it, as another water. And I think, working through some of these agreements, I tend to agree with you, Mel. I think being too prescriptive at this stage is actually going to slow our progress up to actually getting a really good outcome at the end. If we sort of lock everything down and try to do it right at the start, we're more likely to get it more wrong than we are if we have a wee bit of freedom to move and wriggle room and measure it as we go and put the best people in the right places. So, yeah, I just guess from my point of view, I'm sitting relatively comfortable. I don't want to sort of go down to the legalese of things. That's what the lawyers are for. But you know, as a partnership, I think it's just remembering that we're all trying to come together with our own needs. There's going to be a little bit of push backwards and forwards, but I'm pretty happy reading the documents that there's not a whole lot of risk there for us at the moment, because all of the key points for me that I might have any concern about are at least addressed in those documents.
Thank you, Brent. Councillor Slack.
Yeah, around the discussion of having one or two representatives for rural waters, I just want to make the point, and the same is with Mana Whenua representation. And please correct me if I'm wrong, but the way I understand it is that the Mana Whenua representatives and the rural water representative, or TUS, if that would be two, which I don't believe there is a real need for it, but they have no voting rights. Therefore, they would bring in an opinion, they would bring their view of things. But in the end, the decision is with the actual council representatives on the state, or their actual stakeholders, not with the rural water representatives or Mana Whenua.
Thank you, Councillor Hopkins.
Yeah, look, two more questions before we head to attachment 5A. And just a wee comment, Hannah has just shown me section 94 of the Water Services Entities Act, which says constitutions may contain other matters not inconsistent. And basically, section 94 says that skill sets and experience and so on can be and should be criteria for assessment of appointees. So even if it's not in the constitution, it should be part of our deliberations. My questions, there's two of them. One's relatively minor, the other I think is pretty important. On page 53, there's a reference to the admission of new shareholders, and this appears to be considered first by the board and then by the SRG. My question is, does this document need an additional provision for the appointment or the admission of new shareholders in circumstances where the board hasn't been appointed? Because, I mean, at the moment, we're talking about the possibility, well, we're joining, and we'd like to see other councils possibly doing so sooner rather than later. As I understand it, we don't have a board at the moment. And if 13 on page 53 is to be interpreted absolutely as it's worded, we couldn't appoint them because the board wouldn't be able to consider the application. So I'm just wondering whether there needs to be an additional provision in that regard.
I'll just pause you there so that we can get a response to that.
So the establishment partners, the other three councils, have considered the matter of other councils joining and have reached the position whereby they don't think in this establishment period, so once these agreements are over the line in the next few weeks during this establishment period, that it's practical for other councils to join. That window is closed for a period whilst they establish the company, because essentially we were in the last opportunity that they considered for any other council to join them, because there's a lot of work to do. And if you start having other councils join during this period, the danger is you don't get to the 1st of July with your company established, and the 1st of July next year with your company established and your services transferred. So that window is closed. And so, I wouldn't say it's a deliberate omission from there, but it's not the intention to allow others to join during this establishment period.
Thank you. Look, the other question I have on page 61, schedule 4, and I regard this as really important. Under purpose, second paragraph, the purpose of the SRG is to support the coordination of multiple council interests and operate as the liaison between the company and its board and the stakeholders, and between the shareholding councils and stakeholders themselves, including in particular too, and this is the point that I think is critical, appoint, oversee and provide direction to the board. Now, I believe we need a legal definition of the word direction. Does that mean that the SRG can tell the board what it must do, or simply make constructive suggestions? It's absolutely critical.
Isn't it strategic direction?
So I'd like to see that matter legally addressed.
I wonder if the staff have any comment on that, or Amy, whether or not you've got any thought on that at all?
My only comment would be the statement of expectations is a form of direction to the board. So it is right that some direction is provided, but I think there could usefully be some clarity to make sure that it is some guardrails put around that word. So it's right that there is some direction, but it isn't limitless direction. So some clarity wouldn't go amiss.
Thanks, Amy. I think that idea of guardrails around the word is probably the best way here. So there's a bit of finessing there.
We got that?
So which sections are from?
I'll show you. So we're looking for on page 61.
You're right, Alex.
I'm just getting him to show it here. Okay, so point 20. Is that you done, Councillor?
That's me. Yeah, my next questions relate to attachment 5A.
Okay, Councillor McCone.
Sorry to be a pain, but I'm taking everybody back to page 30 and number 4, quorum. So to me, the quorum is covered off by 1.1 and 1.2, but I'd like that a bit more meat in it to say, what is a quorum? How many is there? Is there one representative from each shareholder group before you've got a quorum? So you're not having an unbalanced decision. So a quorum must be one representative from each shareholder group. What is a shareholder? There's a whole lot of stuff there that probably needs filled out and determined so that the playing field stays level.
Right, so are we back on the document before the Constitution? Is that? I find it hard to work it out online at the moment.
It is page 34 to page 30.
Yeah.
Rules for shareholder meeting.
I wonder if the quorum is mentioned somewhere else. I'm not sure. Mr. Hope.
So
I haven't seen it there, but I'd just like, because that's the heading people will go to, and that's the one I would like it seen on.
So this is, I suppose, the most meetings, a quorum of the majority is appropriate. But then, because it needs to be considered in relation to the reserved matters where essentially if it's a significant issue, there needs to be pretty much a unanimous decision or a majority decision. So I'm not sure what additional clarification you'd need. So, I mean, the quorum is just so the meeting can take place. The matters that can be addressed inside of that meeting is really determined by other documents. So could effectively have a quorum, but not sufficient to actually vote on some items. And there might be, it might be something like, oh, there's a special meeting to consider rural water matters, where Gore might decide, oh, actually, we're not interested in this. We don't need to send a member along, but you still want to quorum the meeting for it to be able to operate. So I think a simple majority is probably standing orders for most committees and certainly any local government committee. So.
Would it be fair to say in 4.2, I'm just trying to understand exactly what a quorum sort of is. They talk about the majority of shareholders based on the number of shares held. Is that an intention to make it the voting shares, or do you know what the intention is behind that clause?
Yeah, so for everything, it will be the voting shares. They're the only ones that matter in terms of meetings and everything else. The Class B shares are just placeholders.
So essentially it's a majority of the council representation.
Yeah, so practically for this one, to have a meeting, you'd need to have 3 of the 4 councils represented. And as it grows, you know, that number will change. So it's, you know,
I just wonder because it mentions the majority of shareholders. It doesn't sort of connect them to a place. And that's what I wonder about. Like if you had both missing from Waitaki, you would still get a quorum. Is that how I read it?
No, the council is the shareholder. It's not the representatives. It's the council. So if there was a shareholder meeting, there'd need to be something come to council first in terms of that, in terms of what the council's position was on it and who was going to represent the council. So we need to distinguish this from the representation group. This is a shareholder meeting where the council is represented outside of that representation group.
But aren't we setting the shareholder representatives? Sorry, I'm just trying to tease this out.
So this would be to deal with matters that the stakeholders representation group isn't empowered to deal with or decided it needed the shareholders to deal with. So it'd be for council to decide where, you know, each council would need to make a decision on where it stood on what was being proposed at that meeting and who was going to represent it in terms of voting on that. So similar to what we do with other organisations that we are represented on, you know, agreeing our position and who's delegated to take forward that position. So, for example, yeah, LGNZ mandates and things like that.
so yeah, it may be that there's only one shareholder meeting a year, and that's the AGM to, you know, formally address matters like the appointment of directors, you know, appointment of an auditor, receiving the annual report, because everything else will practically go through the stakeholder group instead. So these will be quite limited meetings.
Councillor McCone.
Yeah, look, again, while I get that, I still would like some protection there for individual districts, or it explained it in black and white what exactly a shareholder is and what the shares are, because it's all very well we can agree what's going around in this table, but in 5 years' time it might be a completely different scenario. So I'd actually like it in written, please.
So I think it is in there that the shareholders are the councils, and that, you know, the shares are allocated as A and B shares, with the A shares being the voting shares. So I think it is there.
Yeah.
Sure that's what it says.
So equal. So it means we've all got equal.
Yeah, so
vote.
each council,
Each
and that would
council-
apply if other councils joined as well.
Each council will be issued 100 A shares.
So in the voting, it means that the voting stays 1 vote per council. Is it? Councillor McCone, you're looking like you need some clarity.
Yeah, again, we're all, you know, I think we all work well together, but I'd just like some clarity, because further down the track we may not.
This goes back to the point about the notice. You know, the councils have to be informed of this, of any meeting. It is then up to the council to make sure they are present and voting in their interest. If they don't turn up, it's not the fault of the other 3, and there's nothing we can put in here to make that any more robust than, you know, you're given the notice. It's up to the council to organise who will represent them and how they will vote at those meetings. It's not possible for anyone to be excluded from those meetings and for that meeting to be valid.
Yeah, again,
McCone.
it's just me, but I'd like to be notified first rather than we've told you, but you haven't turned up, so therefore you've missed out. I'd rather have that in front of us on the way rather than behind us.
Yeah,
So I think there's a requirement for 10 working days notice in here. So you know, if that notice was issued in time, then we would have time as a council to respond to that. So 10 working days gives us a chance to call a meeting of council, decide the council's position on any particular proposal to that meeting, and decide on who will represent the council at that meeting.
Councillor Hopkins.
Yeah, I've got a couple of questions on 5A. Starting on page,
I'll just make sure is everyone relatively comfortable where we've sort of landed in that space in the understanding.
Well, I would simply make the point in regard to Councillor McCone's concerns. Once the Constitution is signed, all the provisions in it will remain in place and in situ unless and until they are lawfully changed. So the protection he wants will be in the Constitution the moment it's signed. But if that's acceptable, I'd move to page 77, 6.2. Negative obligations of council. Between the date of this agreement and council and completion, council shall not basically under 6.2b alter any terms of engagement of any contractor in any material respect, and C, agree to amend any of the terms of any assumed contract in any material respect. Now, my view would be that unnecessarily binds us, because it's entirely possible we might have issues with a contractor and or a contract that have nothing to do with Southern Waters. I mean, I draw your attention to one of our contractors seeking to withdraw from or renegotiate Parks and Reserves contract halfway through. And we've done other contracts like that where they've been amended. And I'm just wondering whether we're actually happy with that binding restriction on both of those between the date of this agreement and completion.
I think it's about offering clarity to Southern Waters and what they're signing up to. Because if you look down at 6.3 and exceptions, you've got an approved by writing from Southern Waters. So basically they're saying, we don't want you majorly changing the playing field. And if things are happening, we want to keep involved. And I think that's probably fair and reasonable considering the amount of handover we've got. We don't want to be doing fundamental changes without them being aware.
I think to add to that, so this is only as it relates to water contracts or contracts that would impact on the company. And it is a potentially live issue for us with the expiry of a contract. But if you put yourself in Southern Water shoes, you wouldn't want any council, whether it's this council or another one, potentially letting a contract that was on unfavourable terms that because essentially that contract will novate to Southern Waters. So I think it's a reasonable request to have in there that is about the success of the company and no council putting it in a position where it's inheriting contracts that put it at some sort of disadvantage.
Yeah, I'm just wondering, however, I take the point about 6.3c, but I'm wondering whether 6.2b and c aren't a little too broad. It doesn't say water contracts or water contractors. It says any contractor and any assumed contract. Looking at page 82, performance of contracts, 9.4 basically talks about contracts that can't be transferred, must be terminated by the council concerned. That council to have no liability to Southern Waters, but also no adjustment to the purchase price. Now, I'm just wondering whether that doesn't potentially expose us to the cost of paying for a terminated contract without recompense. What is the review on that?
Well, I question, I guess, what recompense we have. We've got to remember that we're ring fencing costs around this. So the cost will sit with council or the cost will sit with the entity if there is a cost to break a contract that can't be passed over. So one way or another, our same community are paying that cost. So I think it's probably just for a surety. So I think these contracts are really important at the moment that we're just clear on where different costs fall. And that should be the intention for this. I think us fighting over whether it should sit with the entity or sit with us, it's the same people paying for it.
So I think this is where a lawyer's view would again be helpful, because I think this is governed by law around novation of contracts. whereby, a contractor, I don't think, can unreasonably turn down the novation of that contract. So I think it's a provision in there that hopefully under law we wouldn't, be subject to, but I think it's just a condition that's a bit of a safeguard for Southern Waters in that if there are some obstacles to transferring some of the contracts, but the assumption is that all those contracts will be novated to Southern Water as part of this transfer process.
But look, my last question on 5A, attachment 5A, on page 86, it says, as part of that schedule, or appendix, I should say, that all registered and unregistered intellectual and industrial property rights and interests relating exclusively to the provision of water services are apparently to remain with councils. But the matter is to be finalised depending on whether registered IP is to be transferred to Southern Waters. However, if you go to page 110, which is, I think, a schedule to attachment 6A, but if you go to that page, it specifically says under 5.1, all pre-existing intellectual property remains the property of the original owner, i.e. us. But under B, we agree to procure the grant to the service recipient of a royalty-free, unrestricted, perpetual, non-exclusive, transferable, irrevocable license. And the same applies in B2, where again the service provider will be given this royalty-free, unrestricted, perpetual, exclusive, etc. Access. So it seems to me, the way I read that, we retain the property, or the intellectual property remains our property, but we are obliged to give it to Southern Waters free of charge. And I object to that. Sorry, it's because, look, because because
Jim, through the chair, please.
Because it's our property. We are looking right now at the notion of sources other than rates by which we may be able to offer relief to our ratepayers. And if our intellectual property is marketable and can be monetised, I see no reason why we should not actually endeavour to do so. And I don't believe it should be compulsory to give it away for nothing.
First of all, it comes back to who's paying the bills. And again, it's the same person. So we can charge the entity, which then charges our community for the intellectual property, and our community still pays for it. So you're just transferring funds. And on top of that, there's a whole lot of intellectual property around this, who our customers are, all that sort of stuff that's going to need to go with it for it actually to be a workable product moving forward. So there's so much in this that if we're going to sit there and think we're going to get money for, this is the changeover of the water activity coming from us into the entity. There is intellectual property in that automatically needs to be shared.
Can I add to that? I mean, we need to recognise we're not transferring our water services and this intellectual property that goes with it to some private profit-making entity. It's our company, and we want that company to be successful in delivering water services, and therefore it needs access to that information and that IP to be able to deliver those water services. And yeah, any charge made for it will fall on one group of people, which is the water users, who are the ratepayers and other customers. So this is about ensuring that they have access to that information, but just clarifying that the IP remains ours, but they need it to operate and to be successful for us as our company.
If we tie things up in knots too much, what we do is we actually increase the costs, both for us and for the entity, and probably for some legal people in the meantime, without actually changing the outcomes at all. So I think we've got to be really careful not to bundle this up into something that becomes a huge amount more red tape that costs both us and the entity, because that's our ratepayers paying for that twice over. So I'm just concerned that we go down that track. But I'll go to Councillor Lewis, then Councillor Bellner.
Thanks, Matt Helmdale. I think the key word in that actually is service, and I just wonder whether a clarification should be made that it's any water service on that point, because to allay the fears of Councillor Hopkins, that's if it's specific to that, then that's not relating to any other activity that we're looking at with regards to generating any other funding. So
I wonder at the start of this document if we clarify whose service is enough to add that it's the water services. I'm not, I can't remember, but I'm guessing that's defined somewhere what the service provider is.
Well, I'd almost take the opposite view. We don't want to restrict it to water services because there may be some services we want to provide to the entity on a chargeable or cost recovery basis, particularly in the initial stages, and there will be essentially there will usually be some form of IP embedded in that. So that I suppose there's another mechanism, but restricting it again might complicate something that should be relatively straightforward. I mean, this is there are 3 other councils going into this that have IP, and they may actually have almost something that's more valuable to the operation of the entity that we have, and we'd certainly want that to flow into the entity on a free basis, so we get benefit of this. So it's if we start patch protecting, I think it does fundamentally undermine the basis of the way we're setting this up.
Now, so I will go to Amy first, and then to Councillor Thowning.
Just a very quick point. I just thought it might be worth highlighting that in this Transfer Services Agreement, Schedule 7, which starts down at page 119, has all those definitions. It's quite a weird place to put it. You'd normally see the definitions up the front, but in this one, it's tucked right at the very back. So if councillors check their definitions around assets, contractors, employees, services and things, and the limit of the ones that are only relating to the water services is in there, but it is laid out in quite a strange way. So I'm not surprised if people haven't quite connected the dots.
Thank you. Councillor Thowning.
Yeah, mine's around the definitions as well. On page 75, it says we have to transfer the assets free of encumbrances, and the definition of encumbrances is fairly broad, and I think it's intended to be financial encumbrances. So I understand that the way that the debt doesn't get transferred over, the water service will raise its own debt and pay us to pay off our debt, I understand. But the definition of encumbrance includes other similar instrument, device or power, which might make it a bit more broad and possibly include things like resource management encumbrances or some enforcement encumbrances that we might currently have as well. I was wondering is there a way we could narrow that down or make it specific?
We should highlight it. This is the transfer agreement, so this is the one where there will be a level of negotiation going forward. So it's good to get some of these points early on, but I think there will be a separate process. All that will be included in the resolution that you consider is that wording is effectively that we'll negotiate a transfer agreement that will be similar, substantially similar in form to this one. So I think this is one we'll bring back. I think that's when we can fine tune some of these things. So it's good to understand that so we can provide early feedback. But this is not something you will be adopting in this form on the day. Just saying, okay. I think these are refinements that we can certainly accommodate. It's more, is there anything substantive in here that you would have concerns about that we need to raise really early on? So I think we can capture these things and get greater clarity, but we don't have to do that sort of get exact wording today, but we'll certainly feed these back. So sorry that clarification just at the start be moved into this one, sort of as a flow on from the previous one.
Thank you.
Certainly keep that definition.
Right, Councillor McCone, then Councillor Hopkins.
You just had that further, Paul. I think that's, Sven brings up a very good point, and especially 1.11. So most rural schemes have that title of the water on your actual land title. And so it becomes who actually owns the title, owns the right to take that water. So that needs to be tidied up, because in a legal perspective, it would be interesting Amy's put on that, who actually owns the right to take that water. So there's an encumbrance on that piece of asset that the council say they own.
I think Amy's moving to.
Moving my button finger. Yeah, again, if you look at the definition of encumbrance in that Schedule 7 I was referring right at the back of the document, it does make it clear that it's just limited to mortgage debentures, liens, security for payment. So it is very specifically around just removing any debt instruments. To your point, John, around the rural users and their right to take the water, that would be, those rights would novate to the new entity. So they would still continue to have that right, but against the CCO as opposed to the rural water scheme as it is now. So their right won't be diminished. It will just apply to a new party. But yeah, as I say, that the encumbrance piece there is very narrowly defined to just be around financial interests.
Thank you.
Yeah, a couple of other things. Page 89, Schedule 3 talks about completion amounts, and Schedule 3A1 talks about the external debt of the council incurred in respective assets, etc. Problem I have is that if you then go to the issues and definitions on page 121, it actually says external debt means, brackets, to be determined. Now, I believe it is absolutely essential that we know how external debt is being defined, by whom, when it will be assessed, and unless and until we get that definition, we shouldn't sign off on Schedule 3.
Mr. Hope.
Yeah, fully accept your point, Councillor Hopkins. That's what I'm saying. We're not expecting you to sign off on the transfer agreement as part of the initial decision-making process. It's how we work out what the debt to be transferred. That's going to be one of the most fundamental issues that we negotiate. It will be based off the process that the National Transition Unit sort of put in place, but it will need to be refined for the 4 councils and each of our debt position, and what's the combination of sort of internal, external debt. How we're going to treat things like targeted rates that have been overdrawn, how we deal with funded and unfunded depreciation, accumulated reserves, development contributions. So there's a lot of negotiation to go on in that place, and that's why, as I said, it's just agreeing to the transfer agreement in its general form, and then we'll get into the detailed negotiations of the debt transfer, the asset transfer, issues around IP, operations, staff, all of those things. They'll take a wee bit of time to negotiate.
So you did right, Councillor Hopkins, that we need to understand what that is, and that's to be worked through, and we'll have that back in front of us.
Just one final question or comment from me, Paul, Alex. Page 90 talks about matters of shared interest, and it spills over to page 91, 2.3 minimum requirements. I would simply say that I don't think minimum requirement 2.3c makes sense. It needs to be rewritten. I do not understand it.
So yeah, there's a word missing in there somewhere.
And the other changes I have for are all typos. I'm going to discuss them with you later.
That's a loss.
I think that word maybe provides. Any additional service that one party provides to the other.
Thank you.
when
You're better on
carrying
to
it.
keep an eye on. So provides, if you put that in there, Councillor Hopkins, does that make?
Yeah, look, I was loath to actually add words. It just seemed to me that needed to be done by those preparing the document and or lawyers or both.
Well,
But provides makes perfect sense here.
cool. All right, so that's really just an unpack of what we've got in front of us. Is it Councillor Slack?
Apologies, Madam Chair, but I think we sort of automatically rolled into the transfer agreement
Yeah,
when
sorry.
we hadn't quite finished the constitution yet. But that's all right. I just have one remark or question, suggestion to be made, and that's on page 47, 4.1, and that is regards to the appointments of directors. And I just wonder whether the appointment of the board's chair should be mentioned in here as well. Also thinking that perhaps future councils might join Southern Waters, that it is clear that the chair of the board is actually appointed by the shareholders.
I'm just going back because we had that discussion. It was 47, wasn't it?
It is confirmed in I believe it is the shareholders agreement, if I'm not mistaken. But I just wonder, for the sake of clarity, whether the appointment of the chair of the board should also be mentioned in here.
And I wonder if this is because it's a slightly different version, because it was a conversation we had at the shareholders group, and I thought that was where we landed in that conversation, that the chair would be selected by the shareholders group rather than by the board. So I guess just asking councillors whether that's a position we're comfortable with, because that's what we were sort of pushing for.
4.1 could easily be amended to read, all directors and the chair will be appointed and removed, etc., etc.
Yeah. So yeah, I think that was where that conversation landed. Maybe remind me in that space, Councillor Slack.
Yes, it is. That's where it landed, but it's also confirmed, and I think it's in the shareholders agreement, that it specifically deals with the board.
Yeah.
And just for future reference and for future clarity, I think it should be included in here as well.
No, I think that's reasonable. If everyone's happy. Councillor Holden.
Just on page 49, under the loans and guarantees by shareholders, are we comfortable with the risk exposure there, Paul? There's nothing more that needs to be added into that part.
We're catching up. That's right. We'll give Mr. Hope a wee moment.
Sorry, 7.1, 7.2.
Just allow the reading set.
Well, I think last year we were required to meet. Your microphone's not on there.
Sorry, microphone.
I think 7.1, not required to provide a guarantee. But I think under 7.2, yeah, the relationship with LGFA, especially in the initial stages, there will need to be a reasonable amount of, council will need to stand behind the company until its sort of credit history and operations are established. But this is, I think that's going to be a whole separate negotiation process.
Like, there's obviously a risk associated with that, but also there's probably a bigger risk to the cost implications if we decide to step away from that position, because the entity won't have a credit history. So it's kind of relying on councils for that space. Cool. Councillor Slack.
If we're back at the transfer agreement, I did make very early in the piece, soon after our last meeting, some corrections in there and made some comments in there. I don't know whether you want me to go through there or simply circulate a document with track changes, as they are not major.
I was going to say, if they're material, raise them. If they're immaterial, then probably share.
I think share those, and I think, we've got time for the transfer agreement. So just for clarity, what's being recommended to the other councils, so what Gore's got today and the other councils in the next few days, and what we propose a recommendation to this council is that, is not to agree that transfer agreement. We're a long way from that. It'll be to authorise the negotiation of the transfer agreement. But I think sharing those comments to feed into that process, because I think that's, of all the documents, that's got the furthest to go yet. There's a lot of work needs doing on that.
Yeah, a lot of it is just tidying up, so I agree, and that's why I suggested
Perfect. And if we keep staff in the mix there too, then it makes it nice and simple. All right.
Yeah, I think a lot of this is way beyond my head, but I think it's pretty comprehensive, and while there's some things I don't agree with, that's fine, and we've got to go down that page. One thing timelines, Alex, with our water plan, where do we sit, or how do we sit there? So if we get accepted these guys accept us, we've asked to go with them. Does that make our water plan easier, or do we still got a heap of work to do to make sure we comply by the 30th of June?
Good question.
So there is work to do on the water services delivery plan, but it's I see it as an amendment to the existing plan. You've got to remember, most of our plan passed. It was the asset condition assessment that didn't pass. So we've got to incorporate that in there in terms of the work we've done there and what that's telling us about our assets. And then if there are any changes required to the programme within there as a result of that asset condition assessment, we need to incorporate that. So that work is in hand. And then obviously we need to incorporate the change in delivery model. So the current water services delivery plan says in-house delivery. We need to change it to a joint entity with these councils. So work to do, but it's in hand, and I think it's doable by the time frame that we've been set by the DIA. Essentially the programme going forward is the work continues on the assets. So we're on the physical inspections at the moment that feeds into that final asset condition assessment report, which we'll need to bring to you. We come to you for the extraordinary meeting on the 14th of April, where we'll be making some recommendations about formally adopting the joint CCO with the other councils as the delivery model to go into that water services delivery plan, and also adopting these agreements, not the transfer agreement, but the other agreements around the shareholders agreement and the constitution, and delegating to the stakeholder representative group. There will be other reports that we then need to bring back to you, and other workshops that we'll need in the lead up to finalising that water services delivery plan. I want to try and get that finalised slightly ahead of the annual plan, because it ties into that process as well, because there are some changes in there which sort of talks to the annual plan workshop that we will have this afternoon. Anything else to add to that, Paul?
I'll just pass over to Amy.
Oh, yes, thank you. I was just going to make the quick point. That work that's being done around the asset condition assessment that was required as part of the rejection of the plan will still be of considerable use when the valuation process is worked through for the transfer agreement. So I don't want you to think that you've had to do a lot of work that sort of then becomes irrelevant. That will put you significantly further ahead in completing the valuation process for the transfer agreement. So it is all working towards the same end, and serves you well for both directions of travel.
Yeah, and of course we'll be working with Amy in terms of developing the revised delivery plan, because it was one of the I suppose criteria of her appointment was to make sure that we do resubmit one. So we're working with her, and I think if it's sort of she's comfortable with it, hopefully that means that the DIA and the minister will also be comfortable with it. So yeah, we'll just need to work with Amy over the next, what sort of process she'd like to see over the next couple of months to finalise that plan.
Okay. Well, fantastic. If there's nothing else, then we'll finish up there and we'll have this all back in front of us at different stages. Thank you very much for your time and your help with this one, Amy. It's been appreciated.
Just one
Councillor Hopper.
procedural question. There are various parts of this document where I think ad hoc decisions, a whole lot of things where bracket says this is to be fleshed out or this is to be completed. Do we have a time frame for that, and will those changes be tabled?
Yeah, I think the more, as I said, the individual documents, they'll be tailored, so it's basically just the Waitaki name. Ours will be slightly different because we're going through a different process to the other three. That's all of the documents that will be finalised as part of the April resolution. I think they're very close. And as we said, the transfer agreement is going to be a whole separate process. There'll be, multiple iterations that'll come through this before a final document is adopted.
And I'd say in terms of timeframes for that, you're talking about a program of work over the next year, really, next 12 months in terms of negotiating the detail of that. And that needs to feed into the water strategy that the new CCO will have to develop. So those need to be taken together in tandem. And a lot of work to do around assets and staffing and, transfer of those.
Thanks, Lynn.
All right, so we'll call that to an end. Thank you very much for all the work in the background. And yeah, we'll go have some lunch.